And the Commonwealth's witness that we're going to pre-clear the testimony for evidence.
Yes, Your Honor. Nina Farrish, Dr. Farrish.
Okay. Bring out Nina Farrish, please.
Raise your hand. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? Okay.
Watch your step. There's a stair, and the chair and microphone are adjustable. And Ms. Farrish, we're going to take up some of your testimony outside of the presence of the jury. We'll look at any objections and evidentiary issues, and upon the ruling, we might bring the jurors out, and then redo it. So I just want to explain to you procedurally what's happening right now. Okay. If the attorneys have any questions, we'll start with the combo. Yes, Mr. Rogers?
Before the video played, I would like to coordinate her during the video prior to her actually viewing it.
Okay, and I don't know what order Mr. Jenkins was going in, so do you want to start with the questions, Mr. Rogers?
Judge, may I propose that I lay an authentication foundation, not play the video, let the defense counsel voir dire as appropriate, and then the court will rule whether she can watch the video to authenticate it.
Okay. Yes, please proceed.
Good morning. Could you please tell us your name and how you're employed?
Nina Farrish, Human Resources Director with Newport News Public Schools.
Were you employed in that same capacity in January of 2023?
Yes.
And as part of your official duties as the HR director, were you required to conduct an internal investigation into the shooting at Richneck Elementary School that occurred on January 6, 2023?
Yes.
As part of your investigation, did you have occasion to interview numerous people?
Yes.
And technically, how did you conduct the interviews?
The majority of them I did via Zoom.
Okay.
Recorded.
And did you conduct an interview with someone named Dr. Ebony Parker?
Yes.
And what was, prior to January 6, 2023, what was Dr. Parker's title with Newport News Public Schools?
Assistant principal.
Okay. And do you see Dr. Parker in the room right now?
Yes.
Could you please just point her out for the judge?
Okay.
I'd ask the court to recognize she's indicated the defendant.
So noted.
You've indicated I'll ask it again because I'm not sure what your answer was, but did you do an interview with Dr. Ebony Parker?
Yes.
All right. And was that was that interview conducted in person on Zoom or some other way?
Via Zoom.
Okay. If you were shown that video or clips from that video, do you believe you would be able to recognize it as the one you created?
Yes.
Okay, thank you. For now, I don't have any other questions for you, but defense counsel, I think, does.
Good morning, ma'am. How are you? Great. So, regarding any video that was produced, did you keep, or were you the sole custodian of that Zoom video?
Yes.
Okay, and where was that video maintained?
On my computer.
Okay. Did anybody else have access to your computer, or was it just you?
Just me.
Okay. Did you provide a copy of the video to anyone?
Yes, when asked by the attorneys.
When you say the attorneys, what attorneys?
The ones that represented the school district.
Okay. Did you provide a copy of that video to Mr. Jenkins at Commonwealth?
No, I'm trying to remember the name of the law firm because, as I recall,
so the civil attorneys?
Mr. Jenkins was not the original attorneys.
The civil attorneys?
Correct.
Okay. So have you gotten a chance to review the video that's in the possession of the Commonwealth?
Yes.
When did you review that video?
I reviewed the copy that I still have, and I reviewed it to refresh my memory.
Okay, I want to make sure that you understand my question.
Okay.
The copy of the video that the Commonwealth has, have you reviewed that?
I'm not sure how to answer that question because if I didn't give it to the Commonwealth, I don't know which video then you're referencing.
That's right. So you did not personally give the Commonwealth attorney a copy of the video, and you're not sure that the video that the Commonwealth has is an accurate copy. Is that correct?
That's correct.
Okay. So the video that the Commonwealth has, you don't know if it's actually been altered. Is that correct?
That's correct.
Okay. So you don't know how many hands that video has gone through before it actually came into the possession of the Commonwealth. Is that correct?
Correct.
Okay. So you really can't verify the accuracy of the Commonwealth's video.
Correct.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Okay, and this recorded video, is it stored in your office, or is it stored in the cloud someplace, or is it stored on Zoom's the Zoom app, or how is it actually how is it preserved?
It's on my laptop.
Okay, so you actually have a copy of it on your laptop.
I would call it the original because I've never, except when subpoenaed, made a copy.
Okay, and again, you provided that to the civil attorneys, but not to the Commonwealth.
Correct.
Thank you. I'll tell you what, I'm going to let Mr. Teague say.
Good morning, Ms. Farrish. Regarding the video that you're saying that you recorded, did you record it or did the Zoom platform record it?
Well, I pressed record, but it was the Zoom platform that's recording it.
Okay, so you did not actually record it with your own device or anything like that?
No.
And so the actual video was something that you downloaded from Zoom or was provided to you later via Zoom, correct?
Repeat that question.
You said, I believe your testimony is that Zoom recorded it. You pressed record on the Zoom platform.
Correct.
And Zoom recorded it.
Yes.
And then you were able to, I'm assuming, download it in some way, or how did you get it onto your computer?
I have the Zoom app, so then I just reopen the recording, and it can play for me.
Okay. Thank you.
Okay, and one moment, Dr. Farrish, any further questions while here before we,
Just arguments at this particular time.
okay, your arguments are towards the video?
Your Honor, she testified that she cannot verify the accuracy of the video that the Commonwealth has. She hasn't viewed it. She's testified that she cannot verify that whatever video the Commonwealth has not been altered in some way. There's all sorts of ways to manipulate a video. It could have been run through artificial intelligence and altered. She testified that she can't. She's not in a position to be able to verify that.
Do I have permission to play the video?
Yes. And Ms. Rogers, did you want to say something?
Your Honor, what I don't want to happen is that she's already testified that she cannot verify a video that's in possession of the Commonwealth is accurate. So what I don't want to happen is for her to see the video and just sign off on it without actually having to examine it ahead of time to determine its accuracy.
Judge, if I may.
You may.
The two things I need to say about this. One, the video I'm going to show consists of 3 clips that I intend to admit from a larger video that defense counsel received in discovery back in November. So it has been altered in the sense that I'm only showing the parts that I seek to admit into evidence. Also, it has been altered to mute the name of JT. But if we want to use the original, I have no objection to that. It's just longer and contains what I believe to be pretty irrelevant, but I wouldn't object to it. I'm happy to show it to her now, and we will see whether she recognizes it as being clips of the interview that she conducted.
All right, and the 3 clips, are you able to give me a duration of each clip?
Because they are in one file,
And if you can't, that's fine. I just didn't know if you can.
the total duration of the 3 is, let me make sure before I say.
Your Honor,
16 minutes and 36 seconds is the total duration.
Okay, thank you, Mr. Jenkins. Yes, Mr. Rogers?
Your Honor, Commonwealth has already admitted that the video has been altered. So with that admission, she can't authenticate it. There's been, the Commonwealth would say minor alterations. But Your Honor, I'm not comfortable with just presenting clips. She needs to authenticate the whole video, and if part of it comes in, I think all of it is coming.
Okay. Do you have any authority for that position, Mr. Rogers? Because I'm unaware of the authority that if she is able to say that this is an accurate, fair and accurate representation of the interview she conducted, what authority indicates that it can't be redacted to the relevant parts and that you cannot mute sensitive information such as the names of minors involved? What authority do you have for that that makes it inadmissible?
Your Honor, I don't have any authority regarding the muting or the name of a minor, but I'll just cite Baez versus Commonwealth. And I've got a copy of it before.
And regarding clips, 3 clips versus the entire video.
It doesn't directly address that. It doesn't address that.
Okay,
It just-
but the other thing you're saying, if they get parts, I want the whole one. How do you wish to do that?
Your Honor, I'm going to object to just a part of it because of the importance of context. If some of it comes in, I just think that the jury is entitled to it.
And Commonwealth, we're not objecting to that. So what I'm asking you is, how do you want that? And well, let me back up, Mr. Jenkins. How long is the entire interview?
Oh, I will have to look at that.
That's when I asked Mr. Rogers, are you asking him to play the entire interview?
Yes, ma'am, essentially.
Okay, that's what I want to know. How long is the interview?
So,
The whole video is 28 minutes and 58 seconds, I show. Let's see if that's right.
Okay, that's nice. Okay, all right. So we'll play the whole video for the jury should it meet the other authentication things. Anything else, Mr. Rogers?
that's it.
Okay. So Mr. Jenkins, what are you prepared to play now for the witness?
Well, I can play the whole video if that's what it's going to take to authenticate it. If defense counsel would agree to let me show her a freeze frame and verify, we can do it that way. But.
Mr. Rogers?
So I'm going to ask that she be shown the entire video, but then when it comes comes down to the presentation of the evidence, then I would suggest that the Commonwealth could show clips at that point. But I want the jury to have the whole video. I want the whole video reading of the evidence.
I think I understand that the defense is wanting to admit the entire video into evidence on a disc so that the jury could see the whole unedited, unredacted video and only play for the jury the clips, the 3 clips with the redactions in place. And if that is what the defense is suggesting, I do agree to do that. I think that's fine.
If the court feels that it has been properly vindicated.
Okay, all right, so, we agree to proceed in that manner, except she doesn't need to watch the entire thing. Ms. Farrish, she's going to show you portions of the video and ask you questions about it, but in terms of the entire video, if at any point you say that that's not accurate, please let us know. But I'm
Your Honor.
yes, Mr. Dixon.
Just before we start, I would note that Mr. Commonwealth has indicated that all of the 3 clips have been melded into one file, so they've been joined together, which I think obviously jump would mean that it jumps from clip to clip without the context in between. So I do believe that there may be some issues with playing just those 3 clips, especially if they're in one melded video that's combined into one file. I don't think that would be fair to Dr. Parker, because it would leave out. I'm assuming that he's jumping. Having seen this video, the splice going, it jumps. He's saying that he's joined 3 clips together into one file that plays continuously.
Okay, well, let me hear from Mr. Jenkins.
Judge, the 3 clips that I'm playing are melded together, so to speak, as defense counsel says. But I am happy to tell the jury, and I'm sure Your Honor may as well, that I am showing clips and that they will have in evidence the full unedited, unredacted video. And the jury can know that up front, and I see no problem with that.
Okay, and to the 3 clips, because they're spliced. In between the splicing, is it obvious on the video that this is a splice and we're going to jump forward in time and hear another portion and then we're going to jump forward in time?
It makes a small jitter or jump, it is all, but it doesn't, fade to black and come back up.
Okay, so there's some kind of visual signal that something is happening.
Admittedly, you have to be kind of watching closely because it just jitters.
Okay.
The people move oddly, and that's when the new clip starts.
Understood. Okay, so what is the defense motion? Because Mr. Rogers said it's okay to play it, but as long as they get the entire video for deliberations, Mr. Teague is saying play the entire video. We're talking about 12 extra minutes.
Yes, sir. I think that that's an alteration that goes beyond using people's names and clicking, making splices that are obvious to the jury. I just don't think that should be played to the jury.
Given that, Judge, here, I am offering that into evidence. That is what I'm offering, the clips. And the counsel is free to offer whatever they'd like. They have a copy of the video.
No, we don't agree to admitting a spliced, altered video into evidence. We just don't.
Okay, give me the authority that indicates that that's not admissible. I'm not aware of it. Okay, and Mr. Rogers, what case law has you handed up?
Your Honor, this is Commonwealth, Supreme Court of Virginia, December 19th of 2024. And so I will begin pages back.
Yes, sir.
It says, beginning back here, it says, photograph or video which is verified by the testimony of the witness as fairly representing what the witness has observed is admissible in evidence, and it need not be proved by the individual who made it. And then I'm just going to go on down. It says that the silent witness or a witness that speaks for itself, video or photograph evidence is admissible when given an adequate foundation ensuring the accuracy of the process producing it. Obviously, this splice video is not something that she's going to be able to verify the accuracy. And so, going down to paragraph 22, 23, focusing the authentication quality on one discrete moment is too more to bear on the genuineness of the video as a whole. And then going down to paragraph 24, it says, for a witness to affirm that a video is accurately so in terms of video, the witness is not necessarily a witness is willing to testify at every moment, rather than sufficient for a witness to affirm the video accurately represents what transpired based on the witness's observation. So, Commonwealth has submitted this video as in its form as it's been offered. Obviously, the Commonwealth is going to be presenting a video that points more to Dr. Parker's guilt than innocence. So, in its form, it's highly prejudicial to Dr. Parker, and we don't believe that just those clips should be presented as the Commonwealth has a certain prepared. Obviously, Ms. Farrish has not seen the clips in the form, and so she can't verify the process of how even these clips were produced.
Judge, would you like me to respond?
No, sir. So the court is going to allow the Commonwealth to play the 16-minute clips of what the relevant portions are to the Commonwealth in their perspective. Again, the evidentiary rules are about reliability. Is the thing what it purports to be as proclaimed by the proponent? Are the legal principles involved? And is it a fair and accurate representation? Once those are satisfied, it comes in. I note the defense's exception. Mr. Rogers also brought in the word prejudicial. I don't think he's laid an adequate basis for why this is prejudicial. So you may proceed with your attempts to authenticate this, and then we can get moving with the jury trial.
Okay, Your Honor, given the court's ruling, the video that I'm about to play is the video that the Commonwealth would seek to admit into evidence that has the three different clips.
Yes, sir.
Your Honor, before we go, so there was discussion about if the video was admitted, presenting the complete unredacted copy to the jury. Was that still?
Is that still a defense request? And Commonwealth is in agreement with that?
Yes.
We're just talking about the parts that you all were not able to reach an agreement.
Okay.
Okay. All right. Yes, sir. You may proceed.
Thank you, Judge.
Okay. So Dr. Parker, thank you so much for joining me today. I'm here to first ask if you are giving permission for me to record this session to discuss the incident that occurred in Richneck on Friday.
Yes.
Okay. So as part.
If I may, Judge, ask the witness, does what I've shown so far appear to be the interview that we've talked about?
Yes.
Okay. Judge, I can keep playing a little more, or I believe she's laid a foundation that this is the interview.
Mr. Rogers?
Your Honor, she's only seen my client's face. She's verified that's violent. He was just going to ask it for purposes of identification. There's no way she can verify because what's on this 16-minute clip is accurate. She has to see it.
Ms. Jenkins, if you just jump to two other sections, if you're able to, and play about 10 seconds and ask the same questions.
Okay, I can. Oh, sorry.
I'm seeing at the bottom of the screen a date and time stamp. and those are military hours. So those will move as you move your cursor?
Yes,
Okay.
Your Honor. So I can make a record of those.
Okay, and I didn't know if that's on the video or if you have another cursor mark on your laptop that's showing the different times there.
So I have on the laptop, it is in absolute time, meaning 0 to the end of the video. But what I believe is on here is in the date and time it was recorded.
Oh, understood. Okay, yes, please. Okay, proceed. Thank you.
So I'll resume playing the video from 15:38:28.
And he left. But those are the only two.
Okay. So help me understand.
And Dr. Farrish, does this still seem to be your interview with Dr. Parker?
Yes.
Okay. I'll jump forward a bit more. I've now jumped ahead to 15:47:26, and I'll play from there.
I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay. All right. So just to be clear.
And Dr. Farrish, same question. Does this still appear to be portions of your interview with Dr. Parker?
Yes.
All right. Judge, with that, I think we've laid a sufficient foundation for authentication purposes for this video.
Anything additional from the defense?
Your Honor, just to try to stress the whole point of authentication is to verify accuracy. Your Honor, it's going to be the first time that she's going to see these clips as the Commonwealth has prepared them. We don't know what type of manipulation has occurred from. She didn't give this record to the Commonwealth. She gave it to other attorneys. We don't know what kind of manipulation occurred in the possession of those other attorneys or any IT professionals, any other person between the chain from Farrish, the other attorneys, and just showing her those very few seconds that she's not verifying the accuracy. She's verifying that essentially that's her talking to Dr. Parker. That's it. She's not verifying the accuracy of the contents of that video.
Yes, sir. Okay, so again, the defense will continue to note their objection for the record. The court, again, is going to allow this video to be played to the jury for the rulings it's previously made. But again, the defense exception is noted.
Judge, may I please request to make a quick record related to
I'll
that?
let you make a record.
Thank you.
But the court is also going to give a cautionary instruction to the witness. At any point when this is played, if you see something that is not accurate, please immediately say so we can address the matter.
Yes, ma'am.
All right, thank you. Yes, Mr. Jenkins.
I just want to quickly, in response to, for the purposes of the record, Rule 2901, requirement of authentication. The requirement of authentication is satisfied by evidence sufficient to support a finding that the thing in question is what the proponent claims. So it is not about accuracy. It's about is what it claims. The arguments counsel has made about chain of custody and accuracy of the video, those go to weight, and he is free to make those arguments to the jury. They don't go to admissibility. Thank you for allowing me to do that, Judge. I think we're ready for the jury.
All right. Sheriff, you kindly bring the jury out, and you ask all parties to stand while the jury comes out. If you're able.
Your Honor, I'm going to step out in a second.
Okay, step out, Mr. Rush. Yes, sir. We'll wait till you come back.
Thank you.
I'm sorry, everybody. Get your knees in your back stretch. Yeah, it's a good stretch break. Let's stretch. Here we go. Yes, ma'am. Okay. right, thank you, Sheriff. And again, okay, let's practice again, let's all stand. Let me stretch.
Jurors in the box.
Thank you so much, everyone, to take their seats, please. Do you mind after the head count? All 14 jurors are in the box. Happy Wednesday to everyone. Thank you for the time. This morning. I know you've been there for about 2 hours. We were working on some motions to hopefully keep a swift pace through the day. As usual, we'll try to break around 1. And try to conclude around 5 for evidence for the day. And if you need any breaks, let me know. Now, I have asked the parties, the juror box as a whole, but we have that cautionary instruction not to research this case outside of what's presented to you in the courtroom, not to discuss it with others, and if somebody approaches you, to inform the court. Does anyone wish to report any potential misconduct or issues? Okay, and there is nothing being said, and for the record purposes, parties are shaking their head in the negative. And again, I'll give another cautionary instruction. Again, amongst yourselves, please do not discuss the case or ask questions until this case is given to you for deliberation. That's a specific legal moment and legal procedure. So you can talk about the weather, talk about family, but just don't talk about the case or questions amongst yourselves until the case is given to you for deliberations in that moment. Okay, with that being said, we are going to proceed with evidence today. The witness has already been sworn in, and the Commonwealth will start their direct examination. Mr. Jenkins.
Thank you, Your Honor. Good morning again.
Good morning.
Would you please tell us your name and how you're employed?
Nina Farrish, a Human Resources Director for Newport News Public Schools.
And Dr. Farrish, how long have you been in that role?
For 5 years.
And so were you in that role on January 6, 2023, and in the month of January 2023?
Yes.
Do you know someone named Dr. Ebony Parker?
Yes.
And was she employed by the school system?
Yes.
How so?
As an assistant principal.
Okay. And is she in the courtroom right now?
Yes.
Could you please point her out?
Yes.
And Judge, I'd ask the record reflect that she's identified the defendant.
So noted.
After, did you become aware of an incident occurring at Richneck Elementary on January 6, 2023?
Yes.
And after that incident, were you called upon to investigate it?
Yes.
Generally, what was the nature of the incident you were told to investigate?
A student shooting at Richneck Elementary School.
Understood. As part of your investigation, did you conduct interviews with many people?
Yes.
Did you conduct an interview with Dr. Ebony Parker?
Yes.
And technically, how was the interview done?
Via Zoom recorded.
Okay. If I were to show you different clips that have been edited of that interview, would you be able to recognize those clips as being the interview that you did?
Yes.
Okay. Judge, with the court's permission, I'll publish this to the jury and indicate as well that this is 3 clips from a larger video that we will enter into evidence as well, and that the audio on this has been muted wherever a child's name was spoken. May I publish to the jury?
You may, and for the jury, the defense has objected, and the court has allowed that the video will be played. But do either of the attorneys want the courtroom to be dimmed?
Not necessarily.
Okay, you may proceed.
Okay. So Dr. Parker, thank you so much for joining me today. I am here to first ask if you are giving permission for me to record this session to discuss the incident that occurred at Richneck on Friday.
Yes.
Okay. So as part of our internal investigation, I have some questions for you. I do ask that you please answer the questions honestly. I also ask that you please keep our investigative conversation confidential so that to maintain the integrity of the investigation, because I do have several people I need to speak with. Okay? Okay. So, Dr. Parker, let's start with Friday. Were you given any knowledge prior to the actual shooting that the student had a weapon?
I was told that students reported that the student had a weapon in his backpack.
Do you remember? Go ahead.
So, Miss Kovac, will I use names, right?
Yes, ma'am, please.
Okay, so Miss Kovac was the one who informed me of this. And she said that she had already asked the student, is there something in your backpack? And he said no, but she had brought it to me. The class was about to go outside to recess, so I said, well, when they go outside to recess, we can check his backpack. I was in the midst of the winter growth assessment, printing off tickets and such, so I didn't go into the classroom with her. When she came back, she says, there's nothing, I didn't see anything in his backpack. And I said, okay. And she says, but, what about in his pocket? And I said, well, I don't know. Are they going out to recess? She said, yes. She was also my person that was helping me with testing. So, I don't know if she went outside or not, but there was a comment that said, well, we watched him closely. Assuming she meant herself and the teacher. And I said, okay. And then I went on with testing.
So was all of that conversation from Ms. Kovac all at the same time, or did she come back to you with the comment about we watching him?
She came back.
Okay. So, do you remember approximately what time it was when she reported to you that students reported that he had a weapon?
They were going outside for recess at 12:20, so it was right before that. So I don't know how far between them, but I know from the time that she said it to the time that they went outside for recess, it wasn't very long.
Okay. Did you report this to Ms. Foster?
I did not. I didn't. She was in a meeting with a military counselor that we were supposed to be getting, and I was supposed to be going into that meeting at 1. The meeting was at 1, and I didn't make it into that meeting. But because I was in the midst of testing, I don't leave my office when we're in testing to maintain, the testing tickets and the security of that. And so I had not spoken with Ms. Foster.
Okay. So can you tell me, did anyone else come to you before the shooting to tell you that the student had a weapon?
So after we checked his backpack and there was nothing there.
And you say we?
Well, I say we because I said check it. So, but Ms. Kovac went in to check it.
Okay.
Yes.
Okay.
But I said we because she came to me to ask should we check his backpack? Do we check his backpack? Mr. Rawls, after that situation was settled, came back into my office and he said, "Hey, did you hear what they said about?" I said, "Yeah, I heard." I said, "But we checked his backpack." And again, I'm still using we, but it was Miss Kovac. I said, "His backpack was checked, we didn't see anything." And he says, "Oh, okay. Did you check the person?" And I said, "Ooh, no, we didn't." And I remember looking at the clock and it was 1:40. And this particular student is on a modified schedule. So I said, his mom is due to come here soon. So when his mom comes, we need to inform her of what was said, what we did, and then she can, we'll let her go through the rest of his things and check it. He nodded his head and he left. But those were the only two.
Okay. So help me understand, what is your understanding of what should have taken place from the first notification that you received about the student from Ms. Kovac possibly having a weapon?
What we did in previous times before, we had 2 other students who also were reported to have a weapon, and we, asked the student, do you have something? They say, no, we do have someone else come in with us to look in their backpack, but we never searched a student. So because we didn't, Ms. Clark didn't see anything in the backpack, then we didn't do anything from there. His mother does come in every day, and we have a conversation every day. So I was waiting for mom to come in.
So in the past protocols of what you've done, and correct me if I'm wrong, you've brought the student into your office, and you, along with who else?
So the first time it was Mr. Rawls, and then the second time it was an incident of a parent had already called the police because the report was given to her from her son, so she had already called the police. So the second time it was the police was at the school.
Okay, all right. Had Mr. Zwerner on that Friday come to you and express concern about the student, about the student's behavior, or did she express that she thought the student had a weapon?
No. So Ms. Warner never said that she thought that the student had a weapon, and she never said to me directly that it was reported to her that the student had a weapon. So I was about to get the PM session of the testing started, and she came into my office and she said, is being extremely defiant today. And she says, if he hits me, I don't know what I'm going to do. So I acknowledged what she said, and I said, okay, and then she left. So I told Ms. Kovac, because they were going to look back at the kids, I said, if she feels that he's being, uncontrollable, she can't control him, tell her to call his mother so she can come and pick him up early, is what I said. But no, Ms. Zwerner never came to me and said anything about her fearing that the student had a weapon or that she felt unsafe. She didn't. She didn't say that to me.
Okay, all right, take your time. Had Ms. Zwerner, prior to Friday, ever expressed to you that she had concerns or felt unsafe with this particular student?
No, so has been on a modified schedule since the beginning of the year. His acting out was he's extremely defiant, and he does the exact opposite of what he's asked to do. and it was making it difficult for her to do instruction in the classroom. So we sat down and we made a modified schedule. We had things in place. So somebody was getting the bus. He was going to Miss McBurnett's room to do a social story. He was then transitioned to Miss Kovac for a 15, 20 minute small group session before he spent time in his classroom. And Wednesday, he had asked to come to the office, and he said no. Ms. Zwerner said no, he couldn't come to the office. And he took her phone and threw it down. So it cracked her screen. Ms. Foster and myself, I sat in the meeting, but Ms. Foster had, facilitated the meeting that afternoon with Ms. We told, hey, you don't know the damage that it is to the teacher's phone. We'll let you know. She understood that she was prepared to pay for it and everything. So, in hindsight, that evening, I spoke with Ms. Foster, and she said, I really think I'm gonna call Mom back because he should have gotten a consequence for what he did. And I said, well, yeah, but I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear, at any point in time prior to Friday, did Ms. Zwerner ever report to you that she had concerns about the student or about her safety with that student?
No. The concerns were around the student and his behavior. Never has she said, I feel unsafe.
So when she made the statement to you, if he hits me, I don't know what I'm going to do. Can you tell me where that came from?
So that Wednesday, where I feel it came from was that Wednesday when he took her phone and threw it down, he went to a buddy classroom, which was Miss West. And what Miss West reported to Miss Newton was that he was pinching at her, but I did not get I didn't get the full report of that incident. So when she said that, me knowing that was what was reported Wednesday, that's where I think that came from.
Okay. Okay. Was there ever a comment made to the teacher that she was overreacting to the student or his behavior?
No.
Okay. Prior to Friday, had anyone, Ms. Zwerner or anyone, reported to you their concerns about the student or about their safety or possible safety of others in the building because of that student? Okay. So, staff stating that administration knew, what is your response to
Your Honor,
that?
could we pause the video?
Yes, you can pause it one moment. Yes, sir.
Can I have just a moment to talk with counsel, and then I think I have an objection.
A brief moment.
Your Honor, there's a lot of, I would say, hearsay statements that are being propounded by Ms. Farrish, things that other people may have said. And so I understand the video is coming in, and it should come in regarding my client's statements. But any statements made by Ms. Farrish, I would submit to the court without those are hearsay. Any statements that she is alleging was made or declared by another party, I would submit is hearsay. And I would ask the court to instruct the jury not to consider statements of Ms. Farrish or what somebody else may have said, but only consider my client's responses to those questions.
Judge, I would ask that we continue playing the video for now and make a decision about whether there needs to be some sort of curative instruction after that.
So I will, again, continue to play the video, but I will grant the defense motion that will give a curative instruction. So we'll prepare that when it's time for instructions of whose testimony they can consider from this video and the hearsay. All right, you may proceed, Mr. James.
I don't know.
Judge, may I back up just a little bit to give context?
Yes, sir.
I'm going to start back at 15 hours, 50 minutes, and 0 seconds.
Yes, sir.
Administration knew. What is your response to that?
I don't know. I don't know because what I did and what we did in the moment with how to support with him is what I thought the teachers, Ms. Zwerner, was asking for. Like, just I can't get instruction done. He doesn't sit down in his space. He won't follow directions. Those were the things that Ms. Zwerner were reporting to me.
Okay. I want to go back real quick because I want to make sure I'm clear on something. Ms. Kovac, check the bag. What is Ms. Kovac's title?
She's our reading specialist.
So help me understand why Ms. Kovac why did you direct Ms. Kovac to check the bag?
So, in the midst of testing, I don't remove myself from the office. And when the conversation we had was, should we check his bag? And the reason why we waited till they went out to recess is because I couldn't leave to go and check the bag. So it was my director that said, Ms. Kovac, when they go out to recess, check his bag.
Okay. Did you talk to your resource officer that day?
She was not there.
Okay.
Oh, the resource officer, the actual, I didn't call, no. I didn't call. And our security officer, Ms. Lee, she leaves every day at 2 o'clock.
She leaves at 2, so Ms. Lee was...
I'm sorry, not 2 o'clock, 12 o'clock. And she comes back after McIntosh's dismissal, for our dismissal. So she's with us in the morning from 9 to 12. I'm sorry.
Okay. Okay. All right.
Dr. Farrish, was what you just watched a fair and accurate depiction of some clips of a longer interview that you did with Dr. Parker?
Yes.
Judge, at this time I would seek to admit into evidence a USB thumb drive and an envelope labeled HR Interview Parker that contains the clips that have just been shown to the jury. I would move to enter that as Commonwealth's 2.
I so introduced over defense's previous objections, which were made contemporaneously. Being marked Commonwealth 2.
And Judge, at some point I will need to take a moment to get the full and complete video saved to a drive, and at that time I will move the full video into evidence as well so that the jury will have access to it.
Yes, sir. Any additional questions for this witness from the Commonwealth?
Yes, Your Honor. Dr. Farrish, do you serve as a custodian of records for the purpose of providing things pursuant to a subpoena?
Yes.
And you do that for the school district?
Yes, sir.
Okay. And I want to direct your attention to any publications that the district makes that are official. Is there a rights and responsibilities handbook?
Yes.
And is there one in particular that contains a student code of conduct and also is for the year that was applicable, the 2022-23 school year?
Yes.
Do you have that document with you today on the stand?
I do.
Would you mind pulling it out? And did you bring that with you today?
Yes.
Okay. I'd like to direct your attention to that document. And specifically, if you would look on page 28 of that document, let me know when you're there.
I'm there.
I'm going to just direct your attention to a paragraph that begins principals and school. Do you see that paragraph?
Yes.
I'd like to ask you to read just that paragraph into the record, please.
Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles.
Okay.
Hold on a moment. Yes, what's the objection?
Dr. Foundation, Your Honor. Ms. Farrish is not the author of this document. She has not established that she has authored it or was otherwise familiar with it. She testifies that she responds to subpoenas and things of that nature, but she has not made that the proper foundation has not been made.
Commonwealth?
The court has already ruled on that. It is
We
a...
ruled on hearsay, but we didn't rule on foundation.
Okay. Well, she has testified that on hearsay, we had a ruling that this was a public record. She testified that she is the custodian of records and that what she's reading from is, in fact, an authentic record of the Newport News Public Schools. She brought it with her here today herself, and that it was in effect on the time in question. So that's all the foundation that is needed for her to tell us the content of that document. It is admissible.
The court rules the proper foundation has been laid. If you would repeat your question of what you asked her to read.
Yes, Your Honor. So thank you, Dr. Farrish. This is page 28, a paragraph that begins, principals and school security officers. Could you read that paragraph, please?
Yes. Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles, when there is reasonable suspicion to do so. Students should understand that they have no expectation of privacy to their lockers, personal property, or vehicles allowed to park on school property. Consistent with applicable legal requirements, school division personnel may use search techniques such as metal detectors and use other lawful search techniques.
Thank you. I want to ask you now about a different document. Does the public school system require individual schools within the district to create a multi-hazard crisis and emergency management plan?
Yes.
And during the course of your work, if such a plan is subpoenaed in litigation, are you the custodian of records that would provide it?
Yes.
Do you have with you, or have you brought with you to court here today, the Richneck Elementary Multi-Hazard Crisis and Emergency Management Plan for the 2022-23 school year?
Yes.
And is what you have here today with you a fair and accurate copy of that plan?
Yes.
Okay. Please give me just a moment. I'd like to direct your attention to page 18.
Your Honor, I'm going to request some idea on this, her foundation of knowledge regarding this particular document.
Okay,
If the voir dire is going to admissibility and it's going to be allowed, we will have to remove the jury from the room because admissibility is not a factor for them.
Mr. Tatum,
Yes, sir.
and what's the basis for this again?
I don't think the proper foundation has been laid regarding her familiarity with this document itself. Again, he says that she responds to subpoenas and produces it in response to subpoenas. That does not mean that she has familiarity with the document, knowledge of who created it, or anything of that nature.
So I'm not going to allow additional voir dire at this point. Mr. Jenkins, can you try to lay a better foundation?
Okay, Dr. Farrish, let's back up. Is the multi-hazard crisis plan for 2022-2023 required by law to be created by the schools?
That is my understanding.
Okay, and are the plans records of the schools?
Yes.
Official records?
Yes.
Okay. And is what you've brought here today an official record of the school that was in effect at Richneck on 2022-2023 school year?
Yes.
That's that.
Foundation has been established, you may proceed as a objection is overruled.
So I'll direct your attention to page 18. Do you see the heading that begins imminent warning signs?
Yes.
What they do?
18. And also, I want you to just look over to page 19. Do you see the heading that says mitigation?
Yes.
I am going to ask you to read everything between those 2 points, stopping before the mitigation heading.
Okay.
And also, the court reporter is writing this down, so if you could read relatively slowly to make sure.
Your Honor, I'm sorry, I need to pull that back after someone.
10 seconds.
I'll provide it, Judge.
Thank you. All right, you may proceed.
Unlike early warning signs, imminent warning signs indicate that a student is very close to behaving in a way that is potentially dangerous to self and or to others. Imminent warning signs require an immediate response. No single warning sign can predict that a dangerous act will occur. Rather, imminent warning signs usually are presented as a sequence of overt, serious, hostile behaviors or threats directed at peers, staff, or other individuals. Usually, imminent warning signs are evident to more than one staff member, as well as to the child's family. Imminent warning signs may include serious physical fighting with peers or family members, severe destruction of property, severe rage for seemingly minor reasons, detailed threats of lethal violence, inappropriate possession and or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration. Parents should be informed of the concerns immediately. School communities also have the responsibility to seek assistance from appropriate agencies, such as Child and Family Services and Community Mental Health. Immediate intervention by school authorities and law enforcement officers is needed when a child has presented a detailed plan, time, place, method to harm or kill others, particularly if the child has a history of aggression or has attempted to carry out threats in the past. Is carrying a weapon, particularly a firearm, or has threatened to use one, or exhibits other threatening behaviors.
Thank you, Dr. Farrish. I'm going to direct your attention to just one more section of that same document. We're just going to page 60. And on page 60, do you see the heading Weapons Threat?
Yes.
I'm just going to ask you to read only that section that falls under the heading Weapons Threat.
If a student or other person makes a threat with or about a weapon, gun, knife, or other weapon, evacuate the area, evaluate the perpetrator, isolate, consider lockdown, notify law enforcement, remain calm, get help, avoid heroics, do not threaten, keep a safe, non-intimidating distance, avoid abrupt, sporadic movements, look for an escape route.
Thank you, Dr. Farrish. That's all the questions that I have for you. Please answer any questions from Defense Counsel.
You may.
Still morning. Good morning again.
Good morning.
All right, a lot to unpack. So just to go over, again, you are the HR director
Yes, sir.
for Newport News Public Schools, and you conducted an independent investigation of this whole incident, is that correct?
That is correct.
Okay. And in your investigation of this whole incident, did you have access to the videos from school property or any other videos that...
Objection. This goes beyond the scope of the direct exam and, is also asking about the investigation and other things that I didn't go into intentionally.
It was elicited on direct. That's one of the first things that she testified to, is that was her responsibility to do a complete investigation of this incident.
Okay, and that was one part of your question, but there were other parts. So I'm trying to figure out where the scope of objection lies.
So I'm asking her about how she conducted the investigation. I think it's a fair question, Your Honor.
And what part was your scope of objection towards?
The concern, Judge, is getting into the findings of the investigation, but as to did she conduct an investigation and what did she observe in the investigation, I wouldn't have an objection to that.
I hadn't gotten to the point where I was asking for a conclusion at all, Your Honor.
All right, okay. But if you plan to get there, I think he's going to object.
Well, we'll see what happens as we go along.
All right, you may proceed.
Okay. So you did conduct a complete investigation of this from the beginning of the incident to the end. Is that correct?
Correct.
Okay, and as a part of your investigation, did you view the videos that may have been taken, produced on Newport News School System's surveillance cameras?
Yes.
Okay. Did you also look at videos that may have been produced by Newport News Police Department?
Not by the police department, no.
Okay. So could you describe how many different positions video cameras are placed at Richneck Elementary School?
You want me to describe? You're not asking me how many.
I'm asking you how many. How many different positions, sir? Is it?
I don't recall how many.
Okay, well, let me ask you a different question. Would you say that you could pretty much, through this video surveillance, monitor most of the activities that occurred at Richneck Elementary School?
Most, yes.
Okay. Were you able to see what things occurred in the hallways?
Yes.
Objection, Judge. We're getting into the content of things that he's not planning to show. He should be required to produce those videos if he's going to ask her about those videos.
Response?
I don't think I'm required to show anything. She's testifying. She's producing evidence. I don't have to cooperate that by video.
And what objection is this? What legal principle is invoked here?
Lack of foundation.
Your response?
Your Honor, she's testifying as to what she observed. So, she looked at videos. She's testifying as to what she observed on these videos. So I'm not asking to introduce these videos. I'm just asking her what she observed on these videos.
And are you going to ask her to describe what she observed on those videos?
She is probably, I'm going to ask her to summarize what she saw in these videos, yes.
How is that admissible?
How is it admissible is something that she observed. I mean, she can testify as to what she observed.
Okay, so that goes back to his objection. Why isn't the best evidence rule implicated at that point, or other evidentiary rules? I guess what authority exists to allow her to testify as to what she observed in the video without the actual video? And is this video admissible in and of itself? So if the video is not admissible, how can she testify as to what she saw on the video? How would that also be, by analogy, admissible?
Your Honor, obviously we have already submitted video into evidence.
Well, one video. Are you talking about that video or a different video?
No, I'm talking about the surveillance video, and I think the court and even the Commonwealth is well aware that videos are considered to be silent witnesses of whatever events that they record. If I had the videos, I can. I guess I can ask the court to take a recess so I can show her several videos that the Commonwealth just released.
Okay, 2 questions, or I guess 1 rule. Yes, she cannot testify to what she saw on the video. Second, are you asking to introduce evidence in the Commonwealth's case in chief?
Obviously, evidence is coming in through the Commonwealth's case in chief.
I understand. Is the defense asking to introduce defense evidence in the Commonwealth's case in chief?
Not at this particular time, other than the testimony, Your Honor.
Okay. So, again, my ruling is that she cannot testify as to what she observed on the video. I sustain the Commonwealth's objection. My next question.
Okay, so I'll continue to ask the questions, and then the Commonwealth can object it, and the court can rule.
Yes, sir. And again, to the attorneys, I know that there have been a lot of objections, and there were a lot of objections yesterday, and squirrels all over, and sometimes I might be grumpy, but I'm not grumpy at the attorneys, and they are doing their job, so don't hold that against them. That was a cautionary instruction in the beginning. It is their duty to object, to make sure the rules are followed, and we analyze the rules of evidence. Okay, you may proceed, Mr. Rogers.
Okay. Other than Dr. Parker, were you able to determine the conduct of any other employees that were at Richneck Elementary on January 6th?
Okay, and don't answer. So, and your question was, she able to
observe the conduct, behavior of other parties, other staff members at Richneck Elementary School?
Okay, and in reference to this incident?
Yes, ma'am.
Okay, and your objection is what, Mr. Jenkins?
Authentication, that she's testifying to that, what she would have seen on a video. She wasn't there. She can't authenticate the video, and she can't describe a video that counsel's not producing. It's the same objection.
Your Honor, if I don't have the videos to produce right now, so she conducted an independent investigation. Obviously, she observed a lot of things by video. If the court believes that she should not be able to testify as to what she observed by video, then I'm prohibited.
So I sustain the objection because it's the same thing we just discussed. And
Right.
again, if it can't come into the front door, it cannot come into the back door. Next question.
All right, I'll go to the, let me first talk about you being a custodian of records. Have you testified as a custodian of records for Newport News Public Schools previously?
Yes,
Okay. And so you're the custodian of this document, is that correct?
correct.
Okay. All right. If you'll turn to page 17 of this document.
Yes, sir.
Okay, it talks, I guess, about halfway down. It says teacher removal of a student from class.
Yes.
Actually, let me start at the very top. It says disruptive students in the classroom. Could you read that first paragraph, please?
Under the disruptive students,
Yes, ma'am.
the code 22.1-276.2 provides statutory guidance related to the initial authority of a teacher to remove a student from class for disruptive behavior. The code 22.1-276.01 defines disruptive behavior as a violation of school board regulations governing student conduct that interprets or obstructs the learning environment. The provisions set out below are supplementary to and are not intended to replace the authority of a teacher or administrator to discipline students according to rules described in this handbook. It is the school board's intent that the process of working with students and parents should be focused on seeking solutions to eliminate disruptive behavior in order to improve student achievement and student citizenship.
Okay. So would you agree that this paragraph, which cites Virginia Code 22.1-276.2, gives a teacher the authority to remove a disruptive student from her classroom?
Objection, that's improper opinion testimony. She's not been qualified as an expert to answer that.
Response.
Your Honor, she is here as an agent of the Newport News public school system. She can advise whether or not she believes that Virginia Code allows a student to be removed by the teacher. It spells it out pretty clearly there, but I just want her to verify.
Just rephrase it. I think you can rephrase it as to not to what her opinion is,
Right.
but as to what's in the manual.
Does this manual, which cites Virginia Code, give a teacher the authority to remove a student from the classroom?
Yes.
Regarding your investigation, was JT ever removed from the classroom?
Objection, Judge, this is getting into the findings of her investigation now, which is at the province of the jury to decide.
Wow.
And your response.
Your Honor, I'll submit that to you. I'm not asking for a finding. I'm not asking for a conclusion. I'm asking for a fact. I ask her to determine if something actually occurred or did not occur. That's not a finding.
Okay. So again, legal conclusions are a province for the jury, but how does the finding of this school investigation not come, well, how is that not relevant and admissible.
Judge, the investigation is findings of fact that lead to a legal conclusion. And we have a jury who are the fact finders for this trial. So any findings of fact that are based on her investigation are the province of the jury. And beyond that, Judge, this is beyond the scope of my direct. I did not ask Dr. Farrish opinions or ask her to give any conclusion about any aspect of her actual investigation, because that's the province of the jury.
I'm going to allow it, and over the Commonwealth's objection, the court's rationale is the Commonwealth has introduced the school handbook, the policies and procedures, and the crisis management. And there's been a lot of evidence and questions towards was that followed on that day. So that's a proper subject for cross-examination, and what the school found in all the school policies can come into evidence. We can have a curative instruction later if parties want that the school findings are not legal findings and legal conclusions for this case, and that is for the fact finders, and that is to the criminal charge of child abuse and neglect and endangerment, not to whether or not the school procedures were followed. So that finding of that investigation is not a legal conclusion. So if that's the court's basis, I'm going to allow it in. You may proceed, Mr. Rogers.
Thank you. So Ms. Kovac, if she was having some problems with JT, if he was being disruptive, there was nothing that prevented her from removing him from the classroom. Is that correct?
Correct.
Okay. Are you familiar with Ms. I think I mentioned the name Kovac. I meant Zwerner. So I meant Zwerner. Could you answer the question in regards to Mrs. Zwerner? She could have removed JT from the classroom. Is that correct?
Correct.
Okay. And if Ms. Kovac had contact with JT and thought that he was being disruptive, she could have removed him from the classroom. Is that correct?
Correct.
Okay. If Ms. West had some contact with JT on the playground as a teacher, she could have removed him from the playground. Is that correct?
Correct.
All right. So regarding the multi-hazard crisis and emergency management plan, this is a plan for each individual school. Is that correct?
Correct.
Okay. And are you who's responsible for producing this document, if you know?
That will come under our safety security department.
Okay. Prior to this incident happening, were you familiar with this document?
I know that the schools have them, if you're asking if I'm familiar with this particular one prior to that incident. No.
Okay. And so you have become familiar with this document since this incident has occurred. Is that correct?
Correct. And when you say familiar, again, the custodian of records, it was presented to me. I was not the writer of the document.
Okay. So you said it was presented to you. Other than testifying here today in court, had you read through this document?
Through the entire document, no.
Okay. So your familiarity with this document, was it in preparation for this trial?
For the previous one and this one.
Okay. And would you agree that the policies and procedures in this document apply to everyone that is a employee of a particular school?
Yes.
Okay. So this document would also apply to the teachers in the classroom? Is that correct?
Correct.
It would have applied to Ms. Kovac as a reading specialist, is that correct?
Correct.
Mr. Rawls in his position, is that correct?
Yes.
All right. And so based on these two documents, was there anything in these two documents that prevented Ms. Zwerner, Ms. Kovac, Ms. West, or Mr. Rawls from removing JT from the classroom?
No.
Okay. Is there anything in these two documents that prevented any of those four individuals, Zwerner, Kovac, West, or Rawls, from removing his classmates, JT's classmates, from his presence?
No.
So I'm going to actually go to the page 60 in the multi-hazard crisis and emergency management plan, which the Commonwealth directed you to.
Speak up for me, Mr. Ross.
Okay. Did you hear what I said so far?
I heard you say you were going to go to page 60.
That's correct. Okay, and even when he directed you specifically to a weapons threat. It says if a student or other person makes a threat with or about a weapon, it has bullet points. Are you testifying that each one of these things should occur?
Say that last part again, I'm sorry.
Are you testifying that each one of these things under this weapons threat should occur?
Objection, judge calls for an opinion.
Your Honor, this is the policies and procedures of the school. She's here as an agent of the Newport News Public Schools. She can tell us whether or not it's the responsibility of Newport News Public Schools employees.
That wasn't your question. She can ask you what does the manual say, but your question was whether or not it was applied or followed in the circumstance. So I'm going to sustain the objection.
Okay. So I'm going to ask it in a different way, if I may. Ms. Zwerner, Ms. Kovac, Ms. West, and Mr. Rawls, was it their responsibility to follow these procedures?
Objection, same objection. He's asking for an opinion of whether they should have followed certain procedures.
All right,
All of them or few of them.
Response.
I can rephrase it to make it more clear, I guess. Are they obligated to follow these procedures? And I let him say this objection.
Okay, do you object to that phrasing?
It's been asked and answered, but I don't object.
Oh, you may proceed with that specific phrasing.
Okay, thank you. So you would agree that if they thought that there was a weapon, that each of those individuals should have evacuated the area. Is that correct?
Correct.
For each of those four individuals, if they believe that there was a weapon, they should have.
Objection, Judge. This isn't the question that the court. He proposed to ask her, are they required to follow these policies? That was the question he proposed. That's the non-objectionable question. But he's going down into each of these policies and asking her whether specific people should have followed them at a specific incident or time. And that is an opinion. She has not been qualified as an expert in school security or any such thing. And she should not be offering an opinion about that.
It's not an opinion. She's testifying as to their rights and their responsibilities, Your Honor. So I believe she can testify to that.
State your question.
Was it their responsibilities when presented with?
Was it whose responsibility?
Ms. Zwerner.
That's the same question, yes, that I sustained objection to. Next question.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Ms. Farrish, Dr. Farrish, are you familiar with the training that Dr. Parker or anyone else may have had regarding the rights and responsibilities that are contained in this handbook?
No, I am not.
Okay. And would your response be the same to this document? Are you aware of any training that Dr. Parker or any of the staff members may have received regarding?
No, I am not.
Okay. Your Honor, I'm going to relinquish this witness to my colleague.
To your colleague, Mr. T?
Mr. T.
Okay, Mr. T.
Thank you.
Your Honor, for the record, I'm going to object to bouncing back and forth between attorneys for a single witness and
It's not ideal, but I don't have any authority that says they cannot. Understood. And I think you got something, Mr. T.
Oh, thank you. Good morning again, Ms. Farrish. Are you Doctor or Ms. Farrish?
Doctor.
Dr. Farrish. You were shown a video of about 16 minutes earlier during your testimony, correct?
Yes.
Okay. At certain points of the video skips forward, correct?
The entire video, I didn't see a skip, but I saw a muting at certain sections.
Okay. So are you aware that the entire video was 28 minutes or 28 or 29 minutes?
Based upon the timeline I saw.
Okay. And you were shown about 16 or 17 minutes, correct?
Yes, as I recall.
And is it your understanding that the video clip that you were shown contains 3 different clips joined together?
The video that we saw here
Yes.
was the whole video except the end. It stopped before the very end. So I'm not aware that it's in snippets. It's the whole video.
Okay. So I'm going to pull up the video, the actual video, the whole video.
Okay.
Judge, I'm going to object to this. I don't know what the relevance of this is.
Okay. And I'll give him a moment to respond to relevance.
I'm going to ask the counsel not put that up on the screen until we've addressed
That's fine.
Okay, he's objecting to relevance. What is the defense response?
It's relevant. The witness has testified that she does not believe that the video has been cut up and, certain parts edited out.
Did she say that, or did she say she wasn't able to see that?
She says that she believes that the entire video was shown except the end. That's what she just testified to.
Okay. And what are you purporting to introduce, and under what legal admissibility rule?
So best evidence rule, the Commonwealth has spliced the video, and he's cut out and skipped ahead in the video.
Which we acknowledge.
We acknowledge. So I would like to play more of the video that gives fuller context to the testimony that Dr. Parker was giving in the video.
Okay. And then we agreed that the jury would get the whole video for deliberations. So your objection, and what you're going to play is a part of this whole video?
Yes.
Okay. And so what's the objection?
Well, Judge, it is going to be in evidence. I've already fully stipulated that the version we showed is an edited version and that the full video goes into evidence. Now he's wishing to introduce evidence. We don't have that video, the full video in. So the defense is about to introduce evidence that he has. which they can certainly introduce evidence in their case, but this is still the Commonwealth's case.
So the legal principle here, when we start with my ruling, I'm going to allow it in over the Commonwealth's objection. The basic thing is the whole video is going back there to the jury room for deliberation, and it's offered by the Commonwealth. The opposing side gets the right to cross-examine that, and to have it go back there with the ability to cross-examine is not a legally sustainable principle, does not comply with case law. So he gets the opportunity to cross-examine on anything that's going back there in the jury room. So that's the court's basis. You may proceed, Mr. T.
Thank you, Your Honor. And Dr.
Judge, I'm sorry, I just want to advise that the full video many times contains the name of JT.
Understood.
Okay, the whole name, not initials.
Correct, the
Okay,
whole
well,
name.
how are we dealing with that, Mr. T?
Your Honor, I don't intend to play any portion that gives the name. I can ask some additional questions if we can. I can try to avoid it.
We're talking about, again, audio and press coverage to the world.
I understand.
So
Yeah.
you're able to not to play portions that do not state and the names of any minors.
Yes.
Okay, you may
But just to be safe, I'll just try to elicit the testimony from her directly, and then if I need to, I'll play the portions that I need to.
playing video or not?
It would just depend on her answers.
Okay, you might. Okay.
Okay.
But understand we have that
I
cautionary
understand.
instruction. We are not releasing the names of any minors. Okay, you may proceed.
Thank you, Your Honor. Dr. Farrish, during the narrative that Dr. Parker was giving you in the video of what occurred that day, her actions, did she also mention that in the midst of all of this, she was also attending to two other students that were acting out?
Yes.
Okay. And that was not played in that video that you heard earlier, was it?
I want to just refer back to my notes.
The rest of the school during the test. Dr. Parker was not just in her office ignoring the rest of the school during the testing, correct?
Objection, it's an opinion about something that she did not observe.
I'll rephrase the question, Your Honor. From Dr. Parker's testimony to you regarding the events of the day, she mentioned that there were two other student issues that she dealt with in the school, correct?
Objection, that was the most recent question. It's been asked and answered.
I want to narrow down and go down the path of asking about these two other.
Okay, repeat your question again.
During the day, during the narrative that Dr. Parker gave you, Dr. Farrish, of what was going on regarding her conversations with Mr. Kovac and Ms. Zwerner, she also mentioned that there were two other student issues that she dealt with regarding misbehavior, correct?
Okay, hold on, that's the question. What's the objection, Mr. Jenkins?
This is the second time he's asked that question. Her answer is yes.
Also, just ask and answer.
Yes.
Okay, you can ask it one more time. You can ask it, go ahead, so overrule.
Okay. Do you need me to repeat the question, Dr. Farrish?
Yes, she responded to other issues.
Okay.
Students' issues.
Okay. And one of them being a student was trying to elope from the school, correct?
Correct.
Okay.
Or a student who was an eloper. And
An
there was
eloper.
something that happened.
Right. And that was prior to the shooting, according to your interview of Dr. Parker, correct?
Correct.
Okay. Dr. Farrish, you are an agent of the Newport News Public Schools, correct?
Yes.
All right. And you are aware that the Newport News Public School System is named in civil lawsuits stemming from this event, correct?
Correct.
Okay. And so your employer has a direct financial interest in these proceedings, correct?
Explain that a little more to me.
Would you, as far as you understand, would your employer benefit financially from having Dr. Parker be the one to blame for the shooting?
Objection, Judge. Hold on, objection. That calls for a legal conclusion. She's not an expert in litigation or how that works. And the question assumes facts that are not in evidence regarding another matter entirely.
And her foundation for having that knowledge, her information, so sustained.
Okay. You interviewed Dr. Parker within 2 or 3 days of the shooting, correct?
Correct.
And she gave you permission to interview her and be recorded, correct?
Correct.
Okay. And she cooperated fully with you, correct?
Yes.
You also told her to keep the conversation confidential, correct?
Correct.
Did you ever tell her that she had the right to have an attorney present before speaking to you?
No.
Okay. Did you ever tell her that anything she said could be used against her in a criminal proceeding?
Objection, Your Honor.
A basis for your objection?
Judge, we're going to need to address this at sidebar.
Privately?
I'm asking her what she advised Dr. Parker during this interview.
I'm going to sustain the objection. Next question.
Okay. According to your interview with Dr. Parker directed Ms. Kovac to search JT's backpack, correct?
Correct.
Okay. And as far as what Dr. Parker told you, Ms. Kovac did check the backpack and found nothing, correct?
Correct.
Okay. Ms. Kovac also told Dr. Parker that they watched him closely, correct?
If I remember, the phrasing is that they were watching him.
Watching him closely.
Correct.
Okay. So is it your understanding that Dr. Parker had been told that there was no gun in the backpack and also that he had been closely watched during recess?
Objection. Can we clarify that what we're asking her is about the statement, not about the facts of what happened, but about the statement of Dr. Parker?
Sustained. Can you rephrase to clarify what you're referring to?
Okay. Well, I've already asked the questions. I'll move on. Dr. Parker also stated that JT's mother would be coming to the school to get him shortly, correct?
Correct.
Okay.
Your Honor, if I may,
Yes.
there is something in the background noise. I'm not sure where it's coming from. I don't know if it's somebody's cell phone or, but if we could try to take care of that, it's very distracting.
Yes, I keep hearing it, and it's distracting.
Okay, well,
Yes.
the sheriff will be on top of that.
Thank you.
And I'm hearing it too, but yeah, we'll work on it. All right, thank you. And again, it's 12:23, we're gonna keep going. Again, we'll try to go till 1 for lunch, but do any of the jurors need a break? Okay, they indicate they're good. Okay, I'll proceed with your cross.
Thank you, Your Honor. Dr. Parker also testified or said to you during the investigation that Ms. Zwerner never stated that the student had a weapon, right? And may I ask what you're reading?
It's a transcript of the video.
Okay. Do you have any independent recollection of
I
what?
don't remember her saying Zwerner said the student didn't have a weapon I asked her, did Ms. Zwerner ever say she had concerns about the student and the student being a threat to her or her feeling unsafe?
Okay. Do you recall when the video was played here in the courtroom?
That's what I was trying to remember if Ms. Zwerner said that. I remember Ms. Kovac saying she did not see anything in the backpack.
Do you recall the video today where Dr. Parker was speaking to you in an interview and she stated that Ms. Zwerner never came to her and said that the student had a weapon?
Then, yes.
Okay. And everything that Ms. Zwerner related to Dr. Parker was about behavior of the student, correct?
Correct.
Okay. She also mentioned that they had, prior to this incident, that they had 2 incidents at the school where there was a potential weapon possessed by a student, correct?
You're referring to 2 other times?
Prior to January 6, 2023.
Correct.
Okay. And she also mentioned to you that they've never searched the student without the parents' consent, right?
That they've never searched students.
Okay. And she was also managing state testing that day.
Correct.
Okay. Based on your investigation, did you conclude that this was foreseeable? The shooting specifically was foreseeable?
No.
Right. In fact, you came to the opposite conclusion, correct?
That is true.
In fact, you said that this is something that none of you could have ever imagined, correct?
I'm going to refer to my summary.
At any point, did you say something to go to? Oh, okay.
And just ask for a moment to refer to her notes.
Okay.
I do not recall making that specific statement.
Okay. But you do agree that this, based on your investigation, that this is not something that was foreseeable?
Correct.
Okay. Did you ever make the comment in the civil trial of this matter that this was something that you could never have imagined?
Objection, hearsay.
It's her own statement.
Correct. It's her own out-of-court statement being offered here for the truth of the matter. He can ask her what she believes today, now, but not what she said out of court.
I thought you said during the civil trial. Does that make it in court, or am I missing something here?
It's out of court because it's not within this proceeding.
This proceeding.
Yeah.
She says that she cannot recall, she could not at that time recall making a statement, and I believe she believed I was asking her about the actual report itself that she created.
Okay, well then rephrase, because that's not the question as I understood it.
Okay. Did you ever make a statement during the civil trial that this was not a foreseeable incident?
Okay, no one for the answer. So, assuming she says yes, which I don't know what her answer is going to be, are you going to ask her to then give that statement?
I'm just want to know whether she made the statement.
So you just want an affirmative or a negative response?
Yes.
And your position, Mr. James?
He's feeding her the statement and just asking her, say, didn't you say at the civil trial. He's going to give her the statement, and he expects her to say, yes, I did say that at the civil trial.
I just asked another question. I said, did you ever make a statement to the effect that it was not foreseeable? That was my last question.
Exactly, to the effect that it was not foreseeable. At the civil trial, that is hearsay.
Okay, yeah, understood, and your response to that, Mr. T.
Your
How
Honor.
is it admissible? What exception applies?
I can ask her about her statement. This goes to the foreseeable. You know what? I will try to question, Your Honor. She's already answered that she has determined that it was not foreseeable. So I'll withdraw the question. Okay. No further questions.
Any redirect?
Yes, sir. Dr. Farrish, much has been made about your investigation. Do you have, as part of your investigation, did you complete a Richneck investigation report?
Yes,
And do you have that report with you right now?
yes.
May I approach, Your Honor?
You ain't?
Yes, it documents.
Sure. I believe you have a copy. Judge, I provided to the defense counsel a copy of the plan. Do I need to wait?
To review what you're presenting to the witness.
Of course.
To make sure that it is the same. Okay?
Very good.
Okay, you may approach.
Thank you. Could you just take a moment to just look at each page of that, compare it with the one you brought with you, and let us know if it's an identical copy?
Yes.
All right, so is that a fair and accurate copy of your complete, full report of your investigation?
Yes.
All right, Judge, I move to admit that as Commonwealth's 3, I think.
Your Honor, I'm going to object. This is the investigation, confidential Richneck investigation report that contains hearsay from other parties. It's not admissible.
Response.
The court's ruled otherwise already. Counsel has been allowed to elicit her opinion, the results of her investigation. Counsel has cross-examined her about the conclusions that are in that document. We have had a full interrogation about the facts found by her investigation and her conclusions. To not give the jury that document now is misleading. And so for the rule of completeness, the defense has been allowed to go in and talk about, cherry-pick little pieces that they want to talk about, and I'm seeking to admit the whole document so the jury can see it for themselves.
Mr. T?
Your Honor, we are on cross-examination allowed to ask about anything we want to ask about. It's long in the scope of the direct examination. This is a report that contains hearsay statements from other parties, just as the court has ruled that the jury cannot consider the statements of other people that were mentioned in the video. giving them a full report, replete with hearsay, is beyond pale. It's not useful.
Okay, let me see the document. You may
Of course, may I approach the, oh,
You may,
the
yes,
deputy
I'll
has
share
it.
the text,
Yes,
please.
of course.
Thank you. Appreciate you all.
Your Honor, I would add that Dr. Farrish has not been qualified as an expert. The court will allow a redacted version in, so I will sustain the defense objections as to some of this are not admissible based on the rules of evidence. The court's position is that page 1 and page 8 come in. So the cover sheet and the last page come in, the middle does not. I will remove this paper myself. And does the Commonwealth want the portion removed to be marked Commonwealth rejected?
Yes, please, Judge. Thank you.
Okay. Thank you. Zwerner is amazing. Commonwealth District 3, Commonwealth 3. Rejected 1, rejected Commonwealth 1. Okay, you may proceed with your redirect.
Judge, may I retrieve Commonwealth's 3 from the court to bring to the witness?
Yes, and I'm going to ask, I'll say both of you. Yeah, I do. Your staples work just as good as my staples. Don't damn make a mess. Oh, here we go, sir.
Dr. Farrish, for the purposes of these questions, I'll just ask you to refer to Commonwealth's 3, which I have just handed you after it's been marked and entered by the court. There is a section on the second page of the 2 that were marked called Summary and Conclusion. Do you see that section?
Yes.
Could you please read it?
Yes. An investigation was conducted to review internal processes and establish if there were any deficiencies. From interviews, several employees were told that the student had a weapon. All instances were reported to Dr. Parker, assistant principal. An inquiry was made to Dr. Parker if the student could be searched.
Your Honor, again, I'm going to object to hearsay. Those are statements coming from other people.
You asked for the finding to be in evidence, the findings in evidence. So noted your objection, overruled.
Please continue.
The book bag was searched independently by Ms. Kovac. Permission was never given to search the student. At no time was the principal, Ms. Foster, notified of any communications about the student and the alleged weapon. Dr. Parker never left her office to investigate the situation with the student. Dr. Parker never spoke to Mrs. Foster, although they communicated about other school business prior to the incident. Dr. Parker admitted to handling a prior search situation with another student earlier in the school year, where she brought the student into her office to conduct a search. Although she says previous students' persons was not searched, she admitted that these students were pulled into her office to search their belongings at a minimum. This process was completed with the police or another adult present. Dr. Parker never left her office on the 6th to pull JT into her office. Dr. Parker responded that she could not leave her office due to testing as the reason for responding personally to the report of the student possibly having a weapon. Mr. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and Dr. Parker all had knowledge that the student was in possession of a possible weapon before 2 p.m. Root cause: failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Lack of urgency and attention to multiple notifications. Lack of training and knowledge of the staff on how to handle this type of threat.
Thank you. May I approach the witness, Judge?
You may.
I'll retrieve Commonwealth 3 after you and return it to the court.
Thank you.
Now, Dr. Farrish, previously when I was questioning you and then again with defense counsel, you were asked to read various sections of the Rights and Responsibilities Handbook, including that section on page 28 about principals and security officers under the direction of a school administrator may search students. Do you recall that document?
Yes.
All right, and that document is an authentic manual that provides all the policies that were in place at Richneck in the 2022-2023 school year?
The Rights and Responsibilities Handbook for the district for 22-23.
Yes, that's an official document of the district?
Yes.
Judge, I move to admit that document in whole into evidence as Commonwealth Court. I will have to retrieve it from the witness.
Okay, you may approach.
Your Honor, before that's admitted by the court, could I have a moment, please?
Yes, sir. You can still retrieve it, Mr. Jenkins, and you can pass it to Madam Clerk. I won't receive it until I hear from the defense counsel.
The court already ruled that it would come in, so.
Oh, all right, so this will be marked Commonwealth 4.
May I approach the witness, Judge?
You may.
Dr. Farrish, could you take a look at what I've just handed you and identify it?
Yes, this is the Newport News Public Schools, Richneck Elementary 2022-2023 Multi-Hazard Crisis and Emergency Management Plan.
And is that a copy of the same document that you have that is the emergency management plan that I have asked you about and defense counsel has asked you about?
Yes.
Judge, I move to admit this in whole, unredacted, as Commonwealth's 5. May I approach the witness?
You may.
I just want to make sure our objections no continue.
Yes, yes, continuing objection, which was previously ruled on, and for the record was made, Mr. Lorraine is it.
And I have no further questions for the witness, Your Honor.
Thank you. Any recross?
Yes, Your Honor.
Okay, briefly.
Briefly, Dr. Farrish. Again, the portion of the report that was just entered into evidence, your investigative findings. You were conducting that investigation on behalf of Newport News Public Schools, correct?
Correct.
Okay. As far as your findings, you were not assessing or giving up any opinion on whether Dr. Parker's or anybody or any other employee's conduct was criminal in nature, correct?
Correct.
You also mentioned in your root cause section of your report a lack of training and knowledge of the staff on how to handle this type of threat, correct?
Correct.
And you're referring to the staff as a whole, correct?
Correct.
And according to your report, all of the, I'll just name them specifically, Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and you say Dr. Parker, your finding is that none of them responded adequately, correct?
Objection, Judge. I think that misstates the evidence.
To respond to adequately, I do think it's a misstatement. Can you rephrase?
Okay, all right. In your root cause section, you write, failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Does that apply to all of the people I just named, Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, and Mr. Sims, and Dr. Parker?
Yes.
Okay. No further questions, John.
I have a follow-up, Judge.
Yes, sir.
In the root cause analysis section, is there a phrase that cites the failure to search?
Yes.
And according to the Rights and Responsibilities Handbook, what does it say about who may conduct a search specifically?
That was the one.
We took it away from you.
That's
Can
okay.
I please retrieve Commonwealth's form? The Rights and Responsibilities Handbook. And I can give you a page site. I'll direct your attention in Commonwealth's 5 to page 28, the paragraph that begins principals and school security officers.
Principals and school security officers, under the direction of a school administrator, may search students and student property.
All right. So, given the root cause analysis that involves the failure to search, who was authorized by the district's rights and responsibilities to search?
The school, under the direction of the school administrator.
Okay. And are teachers that work in a school considered school administrators?
No.
Are reading specialists that work at a school considered school administrators?
No.
All right, thank you. I don't have any further questions, please.
Okay, so this, so that paragraph, it starts out principals and school officers, and then it, comma, under the direction of a school administrator.
Objection. I object to counsel reading whatever he's reading from. The witness should be the one reading from the exhibit that the witness has.
reading the same thing the witness has?
Yes, ma'am.
Okay, then go ahead. You may proceed, overruled.
All right, so I'll read it again. Principals and school security officers, comma, under the direction of a school administrator. So would you agree that when it says under the direction of a school administrator, it's referring to somebody other than a principal or security officer?
The verbiage we use at the school district for administrator includes a principal and assistant principals. They are administrators.
Okay, but as this is read, it seems to indicate that they need to have the direction of somebody above them. Do you not see that?
Under the direction of a school administrator.
Principals? Okay, so if I take out it says principals, I can take out and school officers. So principals, comma, under the direction of a school administrator. So that seems to indicate there needs to be some authority above the principal. Do you disagree with that?
Same, Mr. Jenkins, the same. Next question, Mr. Rogers.
That's all I have, Your Honor.
Okay, the status for this witness, may she be excused or does she need to remain sequestered?
I ask that she remain constructively sequestered, but of course able to leave.
Mr. Rogers?
Yes, Your Honor, we
We
agree.
concur. Okay, all right, so Dr. Farrish, that means you are still a witness for purposes of this trial. You cannot discuss the case or discuss your testimony until you receive information that the trial is over. But you do not have to remain in the building or the witness room. You can go about your day, be available by phone if we need to call you back for your testimony.
Yes, ma'am.
Okay, and you'll be informed when you receive frustration ends and when you're released from the witness obligation. Okay, thank you, ma'am, and while you step as you step in.
Thank you.
All right,